Okay. Okay, so can you please find your seats? Yes. So heartily welcome to everyone to this seminar on the World Trade Organization and the trade war, the end of peaceful conflict resolution, where we're happy to have with us as the main speaker, Chad Bown from the Peterson Institute of International Economics in Washington, D.C. I am Arne Melchior, senior researcher and international trade coordinator on international trade research at NUPI. We have a very broad and qualified audience here today from government, from business, from academia, NGOs, and embassies. So thank you all for coming. I would also like to notify you that the seminar is streamed live on NUPI's YouTube channel. So when you take the floor, you should know about that. So this event is part of a NUPI seminar series on global trade policy challenges. During 2018 and 19, we acknowledge gratefully the financial support from the Ministry of Foreign Affairs for the seminar series. As I said, this is on YouTube channel. Some of the earlier events are also available on the YouTube channel. We have also made some policy briefs and shorter articles about trade policy issues as part of this activity. We'll not do it this time because Chad and the Peterson Institute have done so actively themselves, so you could find a lot of information available. I'm sure Chad will inform you about it. So this is, of course, a very special day for the World Trade Organization. It is a step back in trade integration worldwide after a long period of 70 years with increasing integration and with the United States as the leading nation building the world trade system. It was actually the United States that wanted a binding dispute settlement system when the World Trade Organization was established in 1995. So they were a leading force establishing this system, but now the conflict has emerged. It emerged before President Trump. It has intensified under President Trump, and as you all are aware, as of yesterday night, the so-called appellate body is no longer operational because there are too few members. It has had originally 7 members, and there has to be 3 members in each case to be discussed. And from yesterday, there were too few. And this is, of course, because the appointment of new judges to this system has been blocked. So we have had, in Europe, I think we mostly agree on many of these issues about the need for a world trade system and peaceful dispute resolution in this system. In this series, we have had speakers from Brussels, from Germany, from Warsaw, and even from China that mainly agree on these issues. So now I have asked Chad actually to be also, in addition to his impressive academic track record and knowledge in the field, to be a kind of messenger. What's happening over there in the field of trade. So before I introduce Chad, however, I would like to ask Director General Katja Nordgaard from the Department for Economic Relations and Development at the Ministry of Foreign Affairs to have an opening statement. You have the floor, please. Yes.
Yeah. Yes, now it is. Good morning, everyone. It's really a great pleasure to see so many coming here in an early, dark morning in December to listen to a seminar on trade issues. I think that really underlines the importance of global trade, what a hot topic that has become. It used to be for people who were especially interested in this theme, but now it's really in the news almost every day. And we are really pleased to have this seminar series with NUPI because it's important for Norway and for the public in general to understand more of these issues and, of course, how they will relate to Norwegian interests as well. As Arne said, today is an important day. Why? because as of today, the WTO appellate body ceased to be operational. And why is that a problem that warrants a seminar here in Oslo? Well, basically because a well-functioning WTO and the multilateral trading system, of which the WTO is a cornerstone, is the most important trade policy issue for Norway. And because the breakdown of the appellate body undermines the functioning of the very same WTO. And just to be clear, we are talking about a crisis and a major setback, but the WTO has not, as some claim, stopped functioning. The rules of the system are still there, and most members of the WTO continue in most cases to apply them. And there are negotiations going on within the WTO, most importantly on fish subsidies and e-commerce. But turning to the topic of the day. The dispute settlement mechanism is one of the main novelties of the WTO compared with its predecessor, the GATT. It is what gives the organizations its teeth, so to say. And Norway has been part of a few disputes in the WTO and has found that the system, including the appellate body, functions quite well. We are in one such dispute at the moment over the US's extra tariffs on steel and aluminium. In our view, they are an unjustified use of safeguard measures for the protection of the US industries, while the US claims they are needed for national security reasons. We are confident that we have a solid case, but we are, of course, as always, prepared to accept the outcome of the dispute settlement. The US says that its concerns with the appellate body is the way it, in the US's view, has strayed outside its mandate. There might be elements, mainly procedural, that could be improved. These are, however, nowhere near anything that warrants the drastic steps that the US has taken of blocking the new appointments of members of the appellate body. The main strength of the WTO dispute system has probably been the adherence by all major parties and small economies to the conclusions drawn. We have avoided the practice from the GATT area of large economies putting pressure on smaller economies and partners to accept questionable solutions. And we do not want to go back there. While the US has been quite vocal about its complaint and concerns with the WTO dispute settlement, it has been much less clear and forward-coming when it comes to possible solutions to the crisis. And this is one reason why I'm really looking forward to hearing Chad Bown of the Peterson Institute in Washington talking to us today. Because understanding why the US has taken such steps and what they might be expecting to achieve is very important for us in our future expectations for the WTO and the multilateral trading system. Are we moving in a direction, including post-presidential Trump, of more power politics in trade, where the US, China and other major players can be expected to unduly influence dispute results? That would be very grave and undermine the multilateral trading system that has served the global economy and developing countries, and not least us in Norway, so well. Or more optimistically, are there changes that the US wants in the rules of the game that could be worth contemplating to rescue the core elements of the system? And what could they be? These are some of the issues I do hope we can have a good discussion on this morning. So please, Mr. Bown, the floor is yours.
Just heartily welcome to Chad Bown from the Peterson Institute. Has been at the PIIE since 2016, now as a Reginald Jones Senior Fellow. He worked 12 years earlier at Brandeis University and 6 years at the World Bank as a lead economist during some years, 2013 to 16, in the development research group. So Chad has a broad background, and he's an economist by training, but he knows the institutions of trade, which is a reason why he has a strong role in this trade policy field and trade policy research. He also served at the White House Council of Economic Advisors in 2010-11. several visiting fellowships and scholarships, including in Europe and in Sweden twice, maybe, yes, and several editorial board positions, and not the least, a large number of scholarly publications in the field. And as I said, we'll not publish policy briefs this time, but you can listen to the Trade Talks podcast by Chad and with Sumaya Keynes, the economist journalist, and lots of briefs on the PIE website on, for example, there are 2 briefs quite recently on the dispute settlement issue. So you can find a lot of compact material from PIE in this field, and also longer research articles. So please, Chad, you have the floor. We are glad to have you here.
So let me start by saying thank you for the very kind introduction. It's a great pleasure for me to be here. I'm going to take out my phone. I promise I'm not checking Twitter to see if there's been any more announcements of tariffs, though I do have to check every 5 minutes or so. I'm just setting my timer to make sure I don't go on for too long, because I have a tendency to get very excited about this stuff and to talk and to talk and to talk, and I want to make sure that we have plenty of time for answering questions that I don't answer during the talk. So, indeed, I come from Washington, so I'm sorry. As an American, first thing that I always make sure to say is I'm sorry. I indeed have served for a president in a White House, but I like to make it clear, not this White House. I arrived at the Peterson Institute after working at the World Bank for 6 or 7 years. I've also spent a year in the WTO Secretariat in Geneva. I've spent the bulk of my academic career researching as an economist and working on the WTO, on dispute settlement, and on trade remedies. And that's going to be an important part of the story that I'm going to try to tell this morning about our understanding of what's led us to this moment of crisis. Trade remedies in American parlance, trade defense instruments, you tend to call them here in Europe, things like anti-dumping, countervailing duties, so anti-subsidy tariffs, safeguards, and those things. Okay, before we start, let me see if the clicker will work. I wanted to put up some art. So this has been a very trying couple of years. So I arrived at the Peterson Institute after spending 6 or 7 years in the research group of the World Bank as an economist, running numbers, running regressions, collecting data sets. I worked on Turkey and Liberia, and I worked at the World Bank. I moved to the World Bank after a career in academia because rich country trade policy was really, really boring. There was nothing going on in the 2000s on U.S. trade policy, European trade policy, but in developing countries there was a lot of action. So I went to the World Bank where I could try to make a contribution to policy questions that ultimately mattered. By 2016, I'd had a sufficiently rich career at the World Bank in terms of bureaucracy that I decided I wanted to do something else, and so the Peterson Institute called, and I went there. But it was before Donald Trump. He and I kind of arrived on the trade policy scene at the same time. He had quickly, after I arrived, became the Republicans' nominee for the president. In June, obviously, of 2016, we had the Brexit vote in the UK. That was shortly after I started at Peterson. And that really hit home to me, kind of the changing tide in terms of the public interest in trade policy, and really pushed me, I think, to change the trajectory of what I was working on and put to the side some of my longer-term academic research, trying to publish in academic journals, and to focus on some of the more pressing day-to-day challenges of explaining to the public what it is that trade and trade policy actually means, what the WTO is, and things like that. So one of the things that I do, this art here, they're now 14 years old. I have twin daughters. The last 3-4 years, for any of us that have worked in the area of trade policy, there's been a lot of really dark and depressing days, a lot of challenges. But I have wonderful daughters, and they're very artistic. So a couple of years ago, one of the things that I did, they were off, for the summer, and they needed activities, something to do. And as was mentioned, I now do a podcast. Can you imagine there's sufficient interest in the WTO and the appellate body and trade policy and tariffs to support a podcast about this stuff, right? So I do a podcast now that is kind of more successful in terms of the number of people who pay attention to it than I would have ever imagined. And I do it with this wonderful woman at the Economist. She covers trade and globalization for them, named Samaya Keynes. And a couple of years ago, she and I had been working together already a little bit, but she was in London and I was in the US. And I needed to give my daughters something to do to occupy their time in the summer. So what I did is I said, I want you to learn about trade. So I assigned them to read her columns out of. You don't do this kind of thing with your kids? So, every afternoon for a week, I said, you're going to each read, 2 or 3 of Samaya's columns, and I want you to give me an artistic representation of what you think is going on. So this is some of their art of the trade war. And this is what I go back to kind of brighten my day when I'm getting depressed about, things that are happening out there in the real world, like what we're seeing today. Okay. So, and obviously, there's just a lot of different fronts on which the trade war is happening. And today, we're going to focus mainly on dispute settlement and dispute resolution. But what I'm also going to try to do is to tie it all together, because these things really can't be seen in isolation. Even the announcement yesterday coming out of Washington or I guess out of Mexico City, that there is a potential deal to finalize the USMCA, the new NAFTA agreement. Even that has implications or affects our thinking about what's really driving the Trump administration's goals and such for the way it's treating the WTO and the prospects of it and the broader American concerns from that. I'll come back to this, but it's not just the WTO, it's USMCA, the NAFTA negotiations with Canada and Mexico, it's broader relations with Europe, and obviously it's China, right? There's just a major underlying set of concerns that the American policy community in particular has with China. And so let me really start there then. So at Peterson, one of my jobs is to come up with numbers, and then I hand those numbers over to fantastically talented people, and I say, can you put those numbers into something visual that people will look at and say, wow, I don't know what that is, but that's telling me something. And so this is our trade war in one chart, right? The US-China trade conflict in one chart. And what it basically says is these are tariffs. It's measuring tariffs. Small numbers are low tariffs, big numbers are high tariffs, and this is time on the horizontal axis. So before the trade war started in January of 2018, America's tariffs toward China, toward Europe, toward everybody in the world, our MFN tariffs that we didn't have a trade agreement with, were very low, about 3.1%. China's tariffs toward us, about 8%. Not, tragically high, much lower than many other emerging markets, but a bit higher than what we imposed on their stuff. As we've seen, though, that has escalated considerably over the last 2 years, right? We're still awaiting what's going to happen on December 15th. We'll talk to this point later. Are we going to have this phase 1 deal between President Trump and China to kind of slow the trade war down? There's talk, but as of, I have to check Twitter to make sure, but as of now, I think those are still being scheduled, right? We don't think they're going to, we'll think that those will be halted at the last minute, but if they don't, on December 15th, the average U.S. tariff on imports coming in from China will get close to 25%. Right now, it's at about 21%. So it's gone in the scope of less than 2 years from 3% to 21%. China's tariffs retaliating against the United States have gone from 8% to about the same of 21, 22%. Right? This is a pretty big deal, especially for economies of this size. To put these numbers into historical perspective for the United States, I mean, everybody's familiar with the 1930s and the Smoot-Hawley tariffs. The estimates are that tariffs at that time were, in the 30s, something like that. So mid-high 20s is not that far away. Of course, the main difference between today and Smoot-Hawley in the 1930s is when the United States had that bout of protectionism and really high tariffs, it was toward the world, right? Here, this is just toward China. Tariffs toward everybody else still remain relatively low, very low, in fact, in historical terms at, around 3%. So despite the fact that we're being mean to the rest of the world, and we're really not being nice. And I think this was charitable this morning to put it as, bullying smaller countries. We actually haven't raised tariffs all that much against a lot of the rest of the world yet. Could still happen, but it hasn't happened yet. This is just one more chart to show the trade coverage of this over time. So this is a longer historical perspective. So again, China came out of basically self-seclusion, right? Autarky in the late 1970s, first started opening up to the world. In 1980, the United States first granted China most favored nation treatment, right? The typical MFN tariff that all the other countries in the system start getting. But even back then, there were lots and lots of special protections, special tariffs, special trade barriers on imports from China, and that's what this chart basically shows. This extra special tariffs that China's exports into the U.S. market face in any given year, the share of that trade that's covered by that. Before the trade war started in 2017, this was about 8% of China's exports. But the special tariffs that I was talking about, or that I'm talking about, that were in place then, were these trade remedy things: anti-dumping, countervailing duties, the anti-subsidy tariffs. The ones that have gone on since then are not of that variety, right? These are the unfair trade tariffs. We're worried about China's theft of intellectual property, the forced transfer of technology, the mistreatment of foreign investors in the Chinese market. That's what's led over the last year and a half to, by September of last year, half of U.S. imports from China being covered with these special tariffs, to now we're at 2/3, and we could go to almost 100% by December 15th if this next round goes on. But just for some historical perspective, back in the 1980s, we had all kinds of special protection toward imports from China. This was primarily under something called the multi-fiber arrangement, this global system of quotas and voluntary export restraints where countries just weren't allowed to trade all that much. That covered clothing and textiles, right? That particularly impacted developing countries. Back in the 1980s, that's what China exported. To the extent that it exported anything at all, it was primarily low-end, low-value-added clothing and textiles. And back then, about almost 40% of their exports into the U.S. market were covered by this kind of stuff. Okay. Now let me turn to the story of where we are today. I wanted to kind of set the stage with China and the trade war, because part of what we're going to ultimately get into will come back to that and heighten that. But what I do want to try to convince you of is what the administration is doing with respect to its concerns with the WTO and its appellate body are new tactics. But they do reflect some other long-standing concerns that the American policymaking community has had with the WTO and the appellate body. So what I'm going to try to do in my talk, again, I'm an economist. I'm married to a lawyer. I have far too many friends that are lawyers. How many of you are lawyers? I need to be careful about this when I say these things, okay? Okay, so some. Some of my best friends are lawyers. But I'm basically, what I'm going to come down to is this is all your fault, essentially. So what I want to do is to try to tell a little bit of this story here. What I'm going to try to tell along the way is, or what I'm going to try to make clear along the way, is the concerns with the WTO and with the appellate body in particular that are unique to the Trump administration, those that are kind of more broadly shared by the American policy community, and my own feelings. And I'll try to draw distinctions between those two, because I certainly don't share the concerns of the Trump administration. I share some of the concerns with the broader American policymaking community, but not all. And then I have sort of my own take as well, especially about how I think sustainably one might fix what are some of the true underlying problems with this. Okay. But before we get there, let's go back in time and tell a little bit of the historical story about how we got here, because I think it's important to understand that so we can understand how the American frustrations with the appellate body have evolved. And it's not as simple, I don't think, as simply saying that President Trump hates all multilateral institutions and international law, and thus that's why they've instigated this crisis. I think you can feed into that if you're one of his underlying technicians, like Ambassador Lighthizer is. But to his own devices, President Trump wouldn't have any idea what the WTO is or what the appellate body is. It's the people who work for him that know exactly everything about the WTO and that have very strong feelings about the WTO and the appellate body, and know exactly what its weaknesses are and how to tactfully, in a tactician kind of way, put us in the crisis that we are in today. Okay? That requires a tremendous amount of expertise. All right, so the history. Let's go back to the 1980s, before the WTO went into effect in 1995, because I think it's an important period that you have to, or that we all have to kind of understand, to understand how we got to the WTO, how we arrived at the WTO, what's in the WTO, and what contributes to the challenges that it faces today. So in the 1980s, there were a lot of challenges with the trading system. We had this wonderful general agreement on tariffs and trade, the GATT, that came about in 1947, went into effect in 1980 or 1948. But by the 1980s, there were some pretty challenging aspects to the trading system. We had the rise of these things called voluntary export restraints. Back then, it was first Japan, then other countries in Asia that came on the scene. They were the export powerhouses, and they were creating these adjustment pressures of the established, industrialized countries, United States, Europe among them, especially in the United States, imports coming in from Japan, in sectors, some of which you might have heard of: steel, cars, right? So all the things, this is, today it's the same thing, and it's always the same. We had, so Japan was exporting a lot of these products, semiconductors, into the US market, and there was just a lot of political pressure and economic sort of dislocation pressure, which is always there, right? It's always there as you have new traders coming onto the scene, emerging markets coming onto the scene that start to export. There's always, if you're one of the rich countries sort of at the frontier of these industries, you're always facing these kinds of pressures. But in the way it was dealt with in the 1970s and 1980s was through voluntary export restraints. It was telling these countries, don't export to us as much. And if you can't hold yourselves back, then we're going to hit you with tariffs or quotas or something. And so what we ended up with was this complicated web of voluntary export restraints across all these different sectors. And then in addition to the things like the multi-fiber arrangement, which really held back the exports of developing countries in particular, but this really distorted trade flows. It was one of these power relationships between the big rich countries that could say don't export it to us as much, and smaller countries that just kind of had to accept that as an outcome. But it led to systems of corruption where if you had the rights to be able to export, you could kind of divvy those out in the exporting countries in ways that weren't okay. It could lead to collusive outcomes where you have firms kind of holding back output and raising all kinds of economic efficiency concerns, not really a rules-based system. So that was one of the problems in the 1980s, these voluntary export restraints. Other problems were that the new and major emerging export industries in the United States weren't really covered by the trading system. The American export interests at the time were in things like financial services and other services industries that weren't covered by the General Agreement on Tariffs and Trade, which only covered trade in goods. Also not covered were a lot of intellectual property intensive industries, right? Software was starting to come about, computers, pharmaceuticals, media, Hollywood, right? These were the big American export interests of the 1980s. Not much intellectual property around the world, so a lot of theft, piracy, copyright infringements, that kind of thing. So you put all these things together, and the Americans started lashing out. Right? This is their period of aggressive unilateralism. That, and we didn't really have an effective system of dispute settlement at the time. Dispute settlement under the GATT, there was a system there, but any country had veto power. Any country, even a potential defendant country who might have done something incredibly wrong, broken all of the rules, it could stop a dispute from even getting started. It could stop a dispute from getting started, even if it allowed the dispute to get started. If it didn't like the potential ruling in the dispute, it could veto it. Effectively, it meant that there was no third-party arbitration system that worked effectively in the world of dispute settlement. So this led to the Americans lashing out in this period of aggressive unilateralism. This was the, this Section 301 policy that is currently the one being used today against China, right? Motivating the $300-something billion worth of tariffs on China. The one that the administration announced last week could result in new tariffs on $2.4 billion worth of French products because of the French digital services tax, right, under this law. We might not see a WTO dispute there before that retaliation starts to happen. This was the period when the United States was doing a lot of that kind of stuff, going to countries around the world saying, open up to our markets, even for these things that aren't covered under the GATT, start protecting our intellectual property. If you don't, we're going to hit you unilaterally with tariffs. And it's the only way we can deal with this because there's no other system of dispute settlement. Okay? So you put all those things together, right, along with a host of other issues that hadn't been covered, and then ultimately we're left with the Uruguay round and the WTO compromise, right? The grand bargain, where for the first time you get binding dispute settlement, you get coverage of sectors like services through the GATS agreement, intellectual property through the TRIPS agreement. So the Americans get some of what they want on their export interests that are new and that are coming about. And the rest of the world gets some comfort that the Americans will stop acting unilaterally, and if they have grievances, if they have problems with everybody else, they'll use this WTO dispute settlement thing, which under this new system, nobody can block, nobody can veto if somebody's got a problem, so everybody should buy in, right? So that was the kind of the agreement that happened at the time. Now, one other thing that I need to mention during the Uruguay round of negotiations, there were some other important, smaller developments taking place behind the scenes, but kind of a big deal for really in the weeds trade geeks like me, and it will turn out really, really important for the crisis that we face today. And that is there were negotiations as well over these things, these trade defense instruments. Part of this was to deal with the problem of the voluntary export restraints that had happened in the earlier in the 1980s over steel and cars and semiconductors and all of these types of products. So the concern was that there really wasn't a mechanism that would allow for countries to kind of temporarily impose tariffs to deal with the adjustment pressures and then remove them, right? So one of the things that they did was to renegotiate or negotiate the safeguard agreement, the agreement on safeguards. And one of the things, or a couple of the important things that they did in that agreement was they said no more VERs. So VERs are going to be banned, not going to allow them anymore. And the second thing they did was to say, we are going to try to encourage use of these things by getting rid of the compensation that you have to give to countries that are being hurt by this stuff when you impose a tariff, a safeguard tariff. And that had been kind of one of the limitations, right? Under the old safeguard agreement, this thing called Article 19 in the GATT, yes, you could use it, but whenever you imposed one of these safeguards, because nobody was ever being accused of doing something that was unfair, you had to compensate trading partners. So if you had too much imports of steel or of cars or something like that coming into your market, and you wanted to impose a temporary tariff to kind of deal with the adjustment pressure, whether it was an import surge or just too much political pressure from your domestic industry, you were supposed to compensate trading partners for doing so. With the new agreement on safeguards, you would have to compensate trading partners eventually, but you could kind of get away with it for 3 years. Right? There was a 3-year grace period in which you didn't have to compensate anybody. So that's one big change into the trade remedy system to try to help facilitate that use of that policy, which I think arguably economists think is if you're going to impose some protection, is kind of the least bad way to do it. Okay, fine. But another important one, and this is very important for the Americans, and I'm going to come back to this. So if you take one thing away from this, you have to just understand, for whatever reason, how important anti-dumping is to Americans. I can't believe I'm saying this as an economist. It's horrible. It makes no sense. But to Americans, it's kind of the holy grail of trade. So basically, the way to think about it is this. The Americans have extraordinarily low tariffs on average, right? Very low. 3% for an economy of this size is very, very low. And since the 1930s, since 1934 in the Reciprocal Trade Agreements Act, Congress has delegated to the executive branch, to the president, the authority to go out and negotiate with countries to lower their tariffs, to reduce their trade barriers. But Congress has also said, we want you to maintain active trade defense instruments, and in particular this thing called anti-dumping. And politically, if you don't do that, there's going to be repercussions. In the late 1970s, when anti-dumping was being administered by the Department of the Treasury, they were too free trade. They weren't being protectionist enough. And Congress got mad at them and said, you are not imposing enough tariffs when industries come forward and say they're being hurt by dumping, low-priced imports coming into the U.S. market. Treasury, the Treasury Department, we are taking this authority away from you and we're giving it to somebody else. We're giving it to the Commerce Department, right? Commerce has said over the years, this is important. If you want our support for staying in sort of an open trade regime, we have to maintain active access to anti-dumping. So in the Uruguay round, this manifested itself in the negotiations by the American negotiators saying to the world, okay, we agree to all of these different things, binding dispute settlement, new agreement on safeguards, phasing out of the multi-fiber arrangement, all of these different things. But one of the things that we demand in the anti-dumping agreement, and this is where you're supposed to all be flipping through the anti-dumping agreement right now. I'll imagine you're doing it in your heads. Is something called Article 17.6, right? Okay, fine. What does that mean? It's the clause about deference. It's the clause that says WTO arbitrators, if anybody brings a dispute about anti-dumping, you're basically supposed to ignore it. You're basically, well, not quite ignore it, but what you're supposed to do is you're supposed to look at the following. You're supposed to look and see, did the country that is doing the anti-dumping case, did they follow their own rules, their own laws that they have in place? And if they did, then you're supposed to give deference to whatever the domestic investigating agency found in the case. In the United States, this is the Department of Commerce for the dumping decision. Are the prices too low relative to what they should be, the fair prices? And to the International Trade Commission for the injury side. Has the domestic industry been injured, been hurt by those imports that are coming in? If they followed their own laws on this, then you're supposed to give deference, and sort of that's it, right? That's what the Americans negotiated. There was also, one last thing on anti-dumping, very contentious negotiations over something called zeroing that I'll come back to. Zeroing is a massively technically accounting way of basically just getting really high tariffs in anti-dumping cases. It takes basically, when you're doing a calculation about how to calculate the amount of dumping, the amount of low pricing that's taking place in a market, looks at all the transactions that happen and says, well, all the times in which you weren't dumping, we're not going to count those. All the times where your prices were high, and so you didn't actually do anything wrong, we're going to strip those out. And so when we calculate whether or not you were dumping, we're not going to give you credit for any of the times when you were actually not dumping. So as an economist or anybody that has passed second grade math, you would say, what? But this was the way the Americans did things. The Europeans did things the same way at the time too, so it wasn't just us. Americans, this is important to them. The major exporting countries that were getting hit by anti-dumping at the time, Japan, Korea, they all wanted language in the agreement that said, you can't do this. The Americans said, no, we want to be able to do this, so we're not going to allow such language in the agreement. So you look at the agreement, it's silent on this issue of zeroing. It doesn't say, thou shalt be able to zero, but it also doesn't say, thou shalt not be able to do this zeroing thing. So each side sort of walked away from it thinking they got what they had wanted out of the agreement. Kind of constructive ambiguity to get a deal done. But unfortunately, with binding dispute settlement, that kind of thing can come back to haunt you. And that sort of explains where we are today, eventually. Okay, so that's where we were in the 1980s and in 1995. Sorry, I'm just checking to make sure I'm not going too far. You have one of these new phones now, you have to like let it look at you to make sure that it can actually see it. Okay, so what happened? Well, so the WTO comes into effect, right? And now, all of a sudden, here come the disputes. So there's a lot of disputes on the American side that we brought, right? Of course, we're very upset about all the other countries out there in the world, so we have all of our offensive cases against Europe and Canada and Japan on X, Y, and Z, and for the most part, we win those, and those are great. But binding dispute settlement means that other countries bring disputes against us as well, right? And we see lots of disputes on safeguards. So there was, between 1995 and 2002, the United States imposed a number of safeguards on things, small products, brooms, wheat, gluten, minor things to deal with kind of political pressure and import surges. Then the big one in 2002, the Bush administration imposed on steel. Every one of those was challenged at the WTO. And the panels in the appellate body said, no, you can't do it that way. So the negotiators had tried to negotiate an agreement that would facilitate use of trade defense instruments away from those things of VERs that everybody hated into this kind of policy instead. And the judges in Geneva said, no, you can't do this, right? So this is one area that I think there's broad concern that the appellate body just went too far. The negotiators wanted to push use of administered protection into this kind of policy instrument that was non-discriminatory, time-limited, and the appellate body just went too far here. I think there's kind of broad support for that notion, and I'm broadly empathetic with that. But it didn't end there, right? The appellate body, when disputes came against the United States on anti-dumping, continued to rule against, or started, and then continued to rule against anti-dumping, American use of anti-dumping. Interestingly, just as a historical footnote, this issue of zeroing, the United States has now lost like 24 cases over this zeroing issue. You know, a country brings a case, we lose, we stop doing it for the anti-dumping on that particular product, that particular thing, but we do it everywhere, and so everybody else has to, bring. It's just, this is the single most litigated item under the WTO, and we've lost dozens of disputes on this particular issue. But the very first zeroing case did not involve the United States. The very first zeroing case was brought by India against the European Union. The European Union was doing zeroing at the time as well. It lost the case, and then it stopped. Granted, the European system of doing anti-dumping is different from the American one, and there's kind of arguments that it's more challenging for the United States because we have this retrospective system of calculating anti-dumping duties. But in any case, we weren't the only ones doing zeroing at the time. We still haven't fully given it up. But this sort of feeds into Washington's being upset with WTO appellate body rulings because we have lost dozens and dozens of cases, well, 24, say, cases over this same issue. And to them, it looks like we didn't agree to give up zeroing in the Uruguay round. Other countries asked us for it specifically. We refused. And it doesn't say that we can't do it in the text. And we've got this Article 17 thing that says you're supposed to show deference to the way we do things. And the appellate body, you're not doing that either, right? More recently, there have also been appellate body rulings against how the Americans are interpreting public body, or the question of who can grant a subsidy. And here, these are kind of old issues. These kind of not that big a deal. This is the past. Maybe we could live with that. This is kind of the issue of today, right? Because this is China. Since 2006, 2007, the United States has been actively using its countervailing duty law, its trade defense instruments, the anti-subsidy law against imports coming in from China, treating state-owned enterprises as effectively being public bodies, saying a hot-rolled steel company that is state-owned. So hot-rolled steel is the key input to all the downstream steel products, the pipes and the tubes, all of that, you need the primary input, the hot rolled steel. If that's all being provided by a state-owned enterprise that doesn't have to be profit maximizing, then all those downstream companies can get access to this super cheap input that's effectively being subsidized. Now, that's not being subsidized by a government, it's the upstream firm, but that upstream firm is a state-owned enterprise that doesn't have to maximize profits. It just has some other objective function, as we economists would call it. So it should be treated as a public body, somebody who has the ability to grant subsidies. The WTO appellate body has said no. So this is a big bone of contention between the United States and the appellate body when it comes to the critical issue, existential issue that the Americans think of today, and there is broad bipartisan support on this, which is what to do about China. What to do about the fact that China has not become more market-oriented and is doing all these other things which have led to the trade war. So we have all of these disputes against the United States that have built up over time, and that is essentially fed into a number of different things. You can look and interpret, for example, the national security tariffs that the Trump administration imposed in March of 2018 on tariffs on steel and aluminum as something like the following. Americans might say, look, we tried to use anti-dumping to protect our steel industry and aluminum industry. You told us we couldn't do that. We tried to use safeguards, right? Back in the day, we tried to use VERs. You ruled those out. Then we tried to use anti-dumping. Then we tried to use, you ruled out all those other things. We are going to protect our steel industry here. So if you don't like those things, then we're just going to claim to do it for national security reasons. We understand it's completely ridiculous, but you took all of the non-ridiculous ways away from us, right? That's sort of one way that you might interpret. I'm grasping at straws, right, to interpret the Trump administration, but that's one way in which one might interpret the need to resort to the national security argument for tariffs. Similarly, on the Section 301 case against China, the concern is that you look at the appellate body rulings, whether it's on public body or just the WTO rules that aren't there to deal with some of the things that China is doing with its economy, right? Forced technology transfer, for example. Now, I might argue that that's really unclear, right? On the offensive side, there haven't been a whole lot of cases. The United States has put forward legal arguments on offensive interests and lost. And thus, one could have tried to use WTO dispute settlement to address the concerns of China, and we gave up too early. That's my own personal view. Jennifer Hillman has also written about this, potentially filing a big, bold WTO dispute against China, making, claims about non-violation complaints, even though there may not be specific provisions that you have broken. The failure to kind of live within the spirit of the rules has had systemic implications as well. And then obviously what they've done by holding up the appellate body appointments. Now, there is many times this gets lumped in with things that happened under the Obama administration, and so let me make clear the differentiation. Starting in 2007, in fact, the Bush administration changed up appellate body members because they wanted their appointments to more strongly reflect this issue of there should be showing deference to these cases on trade remedies, right? So the American appointment from under the Bush administration, Merritt Janow, was replaced first by Jennifer Hillman, right? 2011, Jennifer Hillman was not reappointed by the Obama administration because I guess they felt that she hadn't strongly enough stood up for American interests. She wasn't too American. She wasn't American enough and of course no appellate body member should be doing that, but that's was sort of the feeling at the time. So she was replaced with somebody else. In I forget exactly, 2014, 2016, the Americans refused to allow the appointment of the South Korean nominee to the appellate body, right? The Obama administration did that. But the distinction between them doing that and what the Trump administration has done is the view of we're not holding up all appointments, just we want to appoint people that have a particular view of how the appellate body should rule on cases. And we're very worried about them going down this path of judicial activism and opining and obiter dicta and all these fancy legal terms. They're not sticking to what it is they're supposed to be doing, especially in these trade defense instrument cases where they're supposed to be showing deference to national authority. It's not just us, right? Other countries should be able to use trade defense instruments as well without facing these excessive challenges, right? So there is a distinction between what the Obama administration did by their refusal to allow certain people to get appointed versus what the Trump administration has done, which is that we're not going to allow anybody to get appointed. Again, this is not me personally. I was not in the Obama administration when those particular decisions were being made. And even when I was there, nobody ever asked me about this kind of stuff. They just asked me about, boring economic things. So I would have explained to them the systemic consequences. All right. Is there a way to fix the appellate body to appease their concerns and save the system? So first, with the Trump administration, and I'm going to say I'm not sure. So I wanted to read a quote from you. So as was mentioned, I do this podcast with Samaya Keynes called Trade Talks. And yes, after this, you all will be forced to sign up for it as the price of entry today. But 2 weeks ago, part of the problem with the Trump administration is we don't actually know what they think. As was mentioned, they have complained, they've stopped the system from functioning, they've refused to accept other countries, other WTO members' proposals, but they have not articulated what they would be willing to accept, right? So on the podcast 2 weeks ago, we had the former U.S. Trade Representative's General Counsel, who had just left, or he's been out since April, I guess, but he's kind of the number 2 at the U.S. Trade Representative's office, and for 20 years he was a law partner of Ambassador Lighthizer, working on behalf of the American steel industry in U.S. anti-dumping cases, right? So they have been working together for decades, and I think if there's anybody out there in public currently that best knows Ambassador Lighthizer's thinking on this kind of stuff, it would be Stephen. He did not speak for the administration, but this is what he said when I asked him the question of sort of why they were doing what they were doing and how they interpreted that. So he waxed nostalgic of the GATT days and basically said of U.S. trade policy during the WTO period. So this is since 1995. After 1994, we decided to take this out of the hands of the voters and out of the hands of elected officials. Trade policy, taking it out of the hands of elected officials. And we chose to sort of seal it up in this cage whereby policymakers wouldn't be able to touch it and would sort of run of its own accord. And the result is the rise of China, slowing economies of the West, dislike of globalization, the rise of populism, and he goes on and on. So basically, the WTO appellate body is the cause of all things evil in the world. It's amazing how much power they've had. And to the specific question of what would you be willing to accept, there was basically silence. For these folks in the administration today and people like Stephen, the good old days were the 1980s. The view that I presented of the problems of the 1980s, the voluntary export restraints, the American aggressive unilateralism, the lack of binding disputes, those are virtues for those kinds of people, right? They look at the American ability to just bully for certain sectors, right? Steel, car, something like that, as a virtue. So they may not have any interest at all in saving the WTO appellate body. So that's, I think, an important thing to note. It just may be that for those folks, there is no, that this is what they want. Where we are today, December 11th, without a functioning appellate body, may be what they want. And we have to take that as a strong possibility. Maybe not, but that's a possibility. Broader American concerns, as I mentioned, are the kind of the trade defense instrument ones. The Washington, D.C. trade bar in particular, right? Yeah, this is their broad concern, that they have been overly constrained on this. As an economist, I look at the data and I measure this stuff and I say, look, these trade defense instruments cover in any given year somewhere between 2 and 5% of U.S. imports, right? So to Europe, which is the main protagonist that the Americans are fighting with at this moment, I might say it's 2 to 5% of imports coming to the U.S. market. Just let them have it, right? If they demand use of trade defense instruments and a bit of flexibility there, just kind of maybe let them have it. Of course, the other side of the Americans, I say, are you serious? We're going to give up the effectiveness of the trading systems, binding dispute settlement? And I agree. The rules are still there. We got some workarounds. We'll talk about those. But we're willing to kind of risk all of that for 2% of American imports, right? And to anybody else who will listen, as an economist, what I would say is, look, part of the problem is this law makes no sense in the first place, right? We have this anti-dumping law that the lawyers will say, is like the Bible, and yet it rests on no good economic principles. The things that you can't do under this law, you're allowed to do in the domestic context, right? A price is higher here than it is here. If that's in the same market, that's perfectly okay. It's profit maximizing behavior. There's nothing wrong with that. But once things cross borders and you see that kind of thing happen, all of a sudden, ooh, that deserves a tariff, right? And that's part of the problem. Just the law on which this thing is founded makes no economic sense. This is not to say that you don't need some escape valve for protectionist pressures, certain instances, certain products, certain trading partners to keep the system going. You certainly do. But you just need a better, more efficient, less kind of crazy legal mechanism to get there, and I think that's where we were headed with the Uruguay round and the changes to the safeguard agreement, until the appellate body just got a little bit too aggressive and said, no, stop doing safeguards. If they hadn't been so aggressive on that, I don't think we would be as nearly poorly positioned as we are today. Okay, so what's happening in the meantime in Geneva? The New Zealand ambassador Walker has sort of taken on board a number of the procedural concerns. The 90-day rule, the decisions aren't coming out quickly enough, the judges are staying on for too long, maybe we'll have the ability to rotate people out of the secretariat. Okay. In the short term, the EU and Norway have put together their bilateral approach to dealing with if there's any disputes between the two of you. We'll have this kind of Article 25 stopgap mechanism of this is the way we'll deal with it. We'll kind of replicate the appellate body within Article 25. There's discussions now going on in Geneva about can we plurilateralize this? Who else wants to take part in this thing? China, maybe other countries. This would be a short-term way to kind of deal with the immediacy of not having an appellate body for all the cases that are in the pipeline. But it won't fix ultimately the underlying concerns or deal with any disputes that somebody might have with America. Now, last slide, why aren't we getting to yes on this very quickly? Or what else? I mean, there's just a lot of stuff going on, obviously. This is the WTO appellate body crisis is just one thing in the broader set of concerns. We've got the bigger issues with the United States or the Western economies in China, some of which are being hashed out through, well, right now bilaterally, but potentially through this trilateral process initially, laying the groundwork for potentially new rules on subsidies, maybe something at some point on forced technology transfer as well. But, beyond that, we've got other challenges, right? The Trump administration, for whatever reason, thinks of the European Union as being as big a problem as China. So we've got frictions there, the constant threat of automobile tariffs, the flare-up of the digital services tax in France, the Airbus-Boeing retaliation after that dispute. So there's just a lot going on. So how do you keep up? This is the point where you take out your phone, and if you don't already listen to Trade Talks, you can just subscribe right there. You find the purple button on your iPhone. So that's Samaya. She is amazing. She's British, so it's much more pleasant to listen to the British accent trying to explain President Trump. And we frequently have her husband plays the voice of Donald Trump on the podcast too. And so it's quite nice. And that's a drawing by one of my daughters. In any case, I hope that's helped to clarify a little bit. But the other thing that I'll just conclude on is if you are confused about what the Trump administration is doing, you have it exactly right. As soon as you feel as though you've figured it out, that's when you should feel like you have a problem, okay? Because there is no grand strategy in what it is that they're doing. And don't let anybody kind of tell you otherwise. The president doesn't know, he's not in the weeds of all of this kind of stuff. And so there's a lot of internal politics within the White House about who has his ear on certain things and affects certain decision. And obviously it's being driven by domestic politics as well. But if you want to know who to follow in terms of the key points, if there's going to be either progress or deviations, changes in behavior and what the United States is doing, it's really the U.S. Trade Representative. It's Ambassador Robert Lighthizer. That's where trade policy decision comes out from the United States. That's who's been given the authority by Congress. So when you see Peter Navarro on television or Wilbur Ross or Secretary Mnuchin, you can watch or not watch, whatever you want to do. But it's really Ambassador Lighthizer that you kind of need to be following for the details of what's actually going to be coming out on the WTO stuff and especially on the China stuff. With that, I'll stop. Thank you.
So thank you very much, Chad, for this excellent presentation. I would like you to stay on the podium. I also ask Katja Nørgaard to join us for the Q&A session. Okay, so, okay. Take this one. So, okay, so thank you very much. This was indeed clarifying and very interesting also to get closer knowledge about the processes in the USA, what's driving policies. I would like to revert to some of the issues, but before that, I would like to ask Katja to tell us a little about the EU-Norway backstop agreement on dispute settlement. I think EU and Canada has also made a similar agreement, and you mentioned that this could be plurilateralized. Will it be plurilateralized?
Wow, that's a big question. I think actually I will need to have my colleagues help me on this issue in the details of this. Evan, I don't know if you could throw.
Well, I can try. First of all, first thing.
We'll have a microphone here too. Yes.
I speak louder. Okay.
Oh, so.
All right. Well, first of all, just say thank you very much for a very useful, very interesting expose of what has happened and why it's happened, and where we're not at the moment. To go back to specifically the agreements or the understanding that we have with the EU. First of all, it was a EU-Canada initiative which we have joined. I think that's one thing. Whether or not it will be, it's using the WTO system's own rules on arbitration instead of using the formal rules of the appellate body. It implies that you decide, the two parties that are involved decide before the end of what the stage before the appellate body would turn in at the stage of the panel, whether to accept the result or move on to an arbitration by outside bodies. So that it needs a decision by each of us before it formally is put on the table. I think that's one change in relation to the present system. And the other one is because we agree among ourselves that when we have an arbitration, we will adhere to the result of that arbitration. The arbitration will be done by former appellate body members. We don't like calling them judges. I'm being told I'm not a lawyer. Like you, I'm an economist. I make that very clear. But our lawyers say we do not call them judges. We call them members of the appellate body. And then we will have to, and we adhere to the result of the process. We see this as as you say, a stopgap way of doing it while the appellate body is out of work. A specific point is that it's only for that period. It will be abolished as soon as we are back into place. And then to the issue of plurilateralism or not, well, that is being discussed today and tomorrow and the next days. There was a certain discussion about whether it should be plurilateralized earlier in the autumn, But that has now re-emerged as a discussion as we are today in this position. And people started thinking about what it should be and how it should be done. But at the moment, it is the only one, the Norway EU, Norway and EU Canada is only formally the only arrangements that are in place, and then we'll see whether it will be. But our impression is that more and more countries are looking at this as a possibility, and we'll wait and see. But I would again emphasize, because that has been the question again and again, whether this is an alternative to the appellate body. No, it's not. It is only there because we feel that there is a need for a two-stage process, and that process has been stopped with the appellate body, and therefore we've had to find something else. So, yeah.
Okay, so I would like to ask you a question about what to do about it in a way. So there are various proposals on the table. For example, one proposal is to carve out the safeguards or the CVD and anti-dumping, the subsidies. So by members of Peterson Institute and Jennifer Hillman. So would that be a solution to kind of have more lax or kind of eliminate the appellate body function for parts of the trade remedy field? From your presentation, it sounds as if one should negotiate on content, on substance, and not only on procedures. So you can, for example, you have these proposals about in important decisions where the appellate body make kind of principal considerations about the interpretation of rules. This should be put into committees at the WTO. But will that lead into another quagmire? Shouldn't you negotiate on these safety valves and kind of clarify the content, not only the 90 days and the procedures?
Well, I think you've hit on it entirely. So I think you can't just negotiate on the procedural elements. The Americans, so again, it's hard to know what they're thinking. And so what I'm going to tell you is based on this conversation that we had with Stephen Vaughan, and it's on the record, and you can listen to it for yourself on the podcast. The way he explained it was essentially the problem that they had was with the decisions that were made, the view of the decision makers that were making the decisions, and that is ultimately kind of the people. And so you just fixing these procedural elements are not going to fix the underlying problem. In his view, the text of 1994 was fine. And American lawyers read that and say it's supposed to show deference to the domestic authorities. It's the interpretations, it's the rulings on that didn't work. So to their view, they don't understand how one could rewrite the text to make it any clearer than what's already there. So, I don't know. I'm not a lawyer. I think you could you can rewrite the text in ways that would make more sense. I would start with rewriting the anti-dumping agreement in a way that would make more sense. The anti-dumping agreement sounds like it has something to do with predation and anti-competitiveness concerns, but it doesn't. There's no elements of that actually in the law. If that's what you're concerned about, then I would suggest that you write a law that's what you're concerned about. But to the bigger question of, is this administration going to be willing to engage on those points? I don't know. There hasn't been any signs that they have. I think we should try. I think we need to put it on them, not just say, I think right now their argument is, well, all you're giving us are these procedural fixes and you're missing the broader point. So I think as soon as the other members are willing to engage substantively on the broader point, rewrite the rules. How you do that, I don't know. You have to reopen the text. Can you just do interpretive notes, general counsel decisions? I don't know the procedural ways in which you do it. But I do think systemically, in order to create a system that is going to be more sustainable, ultimately that is going to be what it takes.
Final question from my side is the U.S. trade policy illegal? In a way, the Trump administration, they have tried to create a kind of justification for the steel and aluminium by referring to the security clause. You said that this is questionable, and it has been questioned. The washing machine, etc., was kind of legal in the sense that it was in the system. But the China tariff, I have not seen any kind of justification that is kind of credible on that. Is this raised? So I wrote in some kind of policy brief that the US behaves as if it is no longer bound by the WTO. Do you agree to this interpretation?
Yeah, so I agree with that. I mean, the safeguard, the Section 201 case on washers kind of came up through U.S. law, so they had to deal with it that way. You know, it was a domestic industry that filed the petition. They had to kind of go through the process, and they imposed tariffs in that way because of that. The national security tariffs on steel and aluminum, those were self-initiated cases that the government decided to do by itself. And the Section 301 case on China is one that it is chosen to do by itself. I mean, so their arguments would be something like the following. The national security tariffs on steel and aluminum, those are legal under the WTO because they should be, you know, non-justiciable, right? Once you invoke national security, it should be, I can do what I want kind of thing. And that's, they think that's covered by Article 21. So they think that is WTO legal. On China, their argument is, the problem with China is it's not doing things that are covered by the agreement. And so we can't find China in violation of something, but that shouldn't restrain us in terms of our ability to respond. Now, I think other people would look and say, well, you know, we've all basically agreed not to use trade policy in ways that, you know, until the WTO authorizes us to do something. So I'm not disagreeing with you. I'm just trying to explain, I think, what their position on that would be, at least in terms of legal arguments. But I think politically, ultimately, it comes down to they don't care about whether something is WTO consistent or not. They're suffering retaliation for a lot of the actions they've already taken. And I think the concern in some of these cases on the steel and aluminum, for example, if those go forward and there's rulings against those, you know, President Trump, the last thing that you want is for him to be thinking about the WTO at all. If those go forward and there's legal rulings against the United States on those, that's going to be a disaster. You could then have just him making the political decision if we need to do something like pull the United States out of the agreement entirely, which I think would be very, very problematic. So that's my big concern, is whether or not those are, you know, legal or illegal under the WTO at this stage is sort of a moot point. I mean, it's bad behavior. The economic effects are there. We all know what it's doing to the system. But if the disputes actually do go forward, things could actually get worse.
Okay, thank you. And then we open for questions from the floor. Yes, Tore Myhre from Norwegian Confederation of Enterprise.
Thank you very much. Great listening to you. What do you think will be the consequences of this? Because the tribunal will still function, but of course, when you cannot take it to the appellate body, maybe the loyalty to the system will deteriorate even further. So what are the medium-term and long-term consequences of this? And secondly, since you're stressing that of course the conflict with China is the underlying problem here, how could the conflict with China be solved within the WTO system in order to make WTO useful for Trump? Because we would like it to be solved within the multilateral system.
So a couple of points there. So the system is likely going to continue to work in some respects for a while. There's a number of cases that are in the pipeline still. The appellate body has to work on the ones that were filed, you know, before yesterday. The appellate body members can stay on and continue to adjudicate those. We do have potentially this stopgap procedure with any countries that kind of want to sign up to it that would deal with appeals in the intermediate term. In terms of trying to negotiate a solution to this, I'm not sure if we will. I think we're now almost at the stage, on the one hand, of people are looking ahead to November of 2020 and saying, you know, that's sort of the critical point in time. If we can kind of muddle through to then, and the U.S. administration, there's a different one, maybe we can have somebody more reasonable to negotiate with. And if this administration really doesn't want to fix the underlying system in a way that would maintain or recreate an appellate body, then there's nothing we can do during that period of time. Or, and again, this is largely, it's speculating because we don't know, truly what's going on in their head. They don't have a white paper on this kind of stuff. It could be that now that minds are focused in Geneva about this issue because there is a crisis, that the administration might be willing to all of a sudden engage. They've got people, this is their sort of maximum leverage to get the changes that they might want to the system. The big challenge, though, is the real fixes are big, and they're going to require some kind of rewriting of rules in addition to just the procedural stuff. And that's very challenging to do quickly. And so if on the other side countries are saying, well, maybe we can wait it out until November, and it may not be the correct alignment of stars to make negotiated change actually happen. So I don't know. I don't have a good answer for any of that. I just kind of walked you through at least some of my thinking about the different scenarios, and I think the way that things are likely to, or what's likely to shape what's likely to happen over the next. But to the separate point of, I think we can already start to see countries, if they don't think there's going to be binding dispute settlement. We talk about the major beneficiaries of the system being smaller, poorer countries that really do rely on the rule of law and not being bullied by richer countries, bigger countries. That being said, a huge amount of the disputes that have taken place under the system have been small country, poor country to poor countries fighting it out between themselves and just looking for a way to resolve their grievances. And the concern is if those countries start to lose faith in the system, what they're going to do to each other, right? This isn't going to be a US-China thing or a US-Europe thing, or this is going to be a Colombia versus Panama thing. And maybe a good example of this is Japan, South Korea, and kind of the challenges that they're having between each other right now that are very important, and yet really aren't being dealt with in any kind of useful way by a kind of intermediate or an international arbitrator, a third-party arbitrator that might help them. Losing that, I think, could be a big deal.
Okay, we have a question there. Please state your name. Yes.
Very interesting, thank you, and depressing, I think. So
At the art again, that'll make you feel better.
Yeah. So the different possible avenues. You mentioned the Walker process, and we have heard EU, Canada, Norway, and making it plurilateral. But a couple of other possible ways. One is if parties in advance accept that the panel decision will be final and binding. Is that a way to pursue? And it has also been proposed that the governing council should, by majority vote, appoint new appellate body members. Of course, that would challenge the US and not be very popular, but could it come to a point that the other members of the WTO would use this possibility to appoint by majority voting?
So yes, so I think on kind of the procedural elements, if two parties want to agree in advance not to appeal the outcome into the abyss, it's sort of always been there as an option for them, and maybe some self-restraint on the appellate body would have been good over the years that no one is self-disciplined. So that's a possible outcome. The voting thing, I think, is a very dangerous step. That's going to, again, be another one of these political things for the U.S. side that I'm not sure you want to push President Trump and the administration there, because you're going to get into the bigger question of whether they're going to have just any participation in the system at all. And when we start to think about that, we're back to this point of even without a functioning body, just having rules of non-discrimination and the transparency and a lot of the we take so much of that for granted. All of that could disappear if the United States withdraws. So I think that would be a really big risk. And my understanding from the European side is they acknowledge that, and they said we're not interested. I think DG Weyand in the European Parliament testimony last week said explicitly they're not going to ask for a vote. So.
Thank you. So the bad news is that we have 8 minutes left. We have 5 questions from the audience, so you have to be brief first behind there. Yes. No, sorry, it was behind there. Yes. Yes. Yeah, you're next. No,
Thank
the
you.
third, yes.
Hildegunn Engedal from the Norwegian Farmers Union and the Trade Campaign. I was wondering, you said something about the problem maybe not being the procedures nor the rules maybe, or as the administration sees it. So what about the members? I mean, what can you do about the members? Now they're down to 1. Will it make a difference when you get the new members in, and how do you, the election of the new members?
We'll just take a bunch of questions and I'll try to...
The next one there, yes.
Arne Ivarsletnes from the agricultural cooperatives in Norway. Thank you very much for a very interesting session here. My question is related to another important role of the WTO. It's the development of new rules. And in your views, what could be the impact of the present situation on the issue of this role, because it's ongoing negotiations or deliberations on fisheries subsidies and agricultural and some other aspects. So would it have some impacts on that? Thank you.
Okay. Perhaps you take these 2 questions.
No, keep them coming. I'll get a whole list here, and then I'll be very efficient.
Okay.
Yeah.
Okay. So then your turn.
I don't want anybody to get cut off.
David Llewellyn, you mentioned the lack of a Trump strategy. Isn't it quite simple? It's all about protecting jobs. And at the end of the day, I think that applies to China and Europe. And so actually thinking of it from that perspective, it may just be about getting votes at the end of the day by protecting jobs. So how does that, could you comment on that?
Okay, one more here. Yes.
Thank you very much. I prefer to stand. My name is Perry Solgi. I am the Central Board member of the Norwegian Labour Party International Forum, and I'm a lawyer, not an economist. You have spoken a lot about the one side of the problem, that is USA, but we haven't not heard much about China, who is one of the biggest partners and also the problem. So do you think China will abide by the rules and the WTO and China? Where is China in this picture? Thank you.
Okay. Then we take the last question here from Hege Medin, NUPI.
Well, I'm Hege from NUPI, Hege Medin. Thank you very much for an interesting presentation. Very interesting. I'm wondering if you think the dispute settlement mechanism in bilateral trade agreement will become more relevant now with the troubles in the WTO. Because, for example, Norway has about 30 bilateral trade agreements with countries all over the world, and all these contain dispute settlement mechanisms, but they have never been used. So I'm wondering, would we see a rise of use of those kind of mechanisms instead?
Okay, thank you very much. So perhaps you can respond.
Sure.
Yes.
So to the question of the new appellate body members, so I think this is certainly, if there is ever a functioning appellate body again, there will be enhanced scrutiny on who they are, and what they have written, what they have said in ways that we perhaps didn't see before. Obviously, this has shown such light on the issue. In the United States, when we have new Supreme Court judges being appointed, it's this massive investigative procedure of everything they've ever said or written or blah, blah, blah. So maybe we'll see something like that. But all that being said, I think it's not only the process for appointing new appellate body members, the rewriting of rules, but we need a better system. The fundamental underlying problem with all of this is we have had no way to make tweaks to the rules over the last 25 years. And when the appellate body members started to make these rulings that kind of arguably went too far politically on zeroing or safeguard, there should have been a way to rectify that legislatively in real time, right? And not have it build up to this point of today. And the problem is we've had no way to make modifications to the rules in real time. And that's a function that's needed in the WTO, or else we're just going to find ourselves back at this point again at some point down the road. And so I think that has to be brought in as well. Fisheries, yes, there are all these other things that are going on as well. I think in an ideal world, there's so much that needs to be dealt with. You could imagine packaging a lot of these things together and fixing a lot of problems at once. Right now, all of these things are being negotiated in silos, right? Where none of them may get done because there may be one major party in that particular agreement that just doesn't want to have it get done. There's nothing in it for them, and they stand to lose. But if you were to put a number of these things together, the trade-offs might be there so that everybody would be winners at the end of the day. That's not going to happen in the short term, but maybe if it doesn't happen now and we get a more constructive American administration a year from now, that's maybe a way out of it. So I think it's something to look forward to. On the question of bilateral trade agreements instead, I mean, that is a possibility. There's challenges there. You know, you get inconsistent legal rulings across the, there's not all of those procedures are as transparent or have qualified panel, panelists, rosters of panelists that are eminently qualified, so there might be issues with the quality of rulings that come out of it. You're exactly right that most of the NAFTA agreement's a great example. The dispute settlement procedure was tried for a while. It was blocked, shut down, and there's been more than 30 disputes between the United States, Canada, and Mexico under the WTO. Maybe it'll go back to that, but I think new challenges would arise if countries started to resort to those kinds of procedures. Protecting jobs. In my view, there's just as many jobs on the export side of things as there are on the import side of things. So yes, he's clearly protecting for political reasons certain jobs, but he's exposing other jobs, right? Look at the retaliation that's happening, right? Look at the soybean farmers that are getting crushed. Look at all the downstream users of steel and aluminum in the United States whose companies are suffering because of the tariffs and the protection. So yes, he claims it's about jobs, but as an economist, I say, no, that's not what this is about. Politically, yes, but in reality, no. China in all of this, I agree. And ultimately, what is going to be the long-run end game of anything for it to be sustainable is you have to negotiate with China something that they can accept. Something that they will be able to find in their own self-interest and be able to sell politically, and it's also a win for them economically. Maybe it's part of a bigger package of issues, but you're not just going to be able to foist upon China some agreement that says you have to do exactly what we say. And I think that's what the really big challenge is, coming up with new rules, especially on subsidies, state-owned enterprises, that they would be willing to sign up to as well. I think personally, as I look at this analytically, there's lessons that we can learn from countries like Norway and how the EU deals with their various economies that have state-owned enterprises and manages the competition issues that arise there. China's obviously on a much greater scale, but I think there's approaches that can be adopted from thinking about things that way that the United States hasn't gotten to yet, but that could eventually be a way out of this as well. Thanks.
So thank you very much, Chad. We are on time. I will finish by asking you, both of you, one question or two questions. So, so the first question is, who cares? And the second is, who are your friends? Or I think on the alliances dealing with it. Here we think this is a big crisis. Do they think so all over the world? And the second is we tend to agree on the need for a multilateral dispute settlement, etc. But the United States has a lot of friends in the WTO. How are these alliances? A brief comment on how strong is the U.S. How are they, and what are the Norwegian friends, the Canada group, etc. What role will it play?
Yeah, I don't think the U.S. has any friends at the moment.
Okay.
So no, when I talk to American negotiators, one of the challenges they explained to me, somebody who watches this on the outside, is, look, even if we have specific proposals and fixes, we can't table those because just by them being seen as American, they would become toxic. And everybody would disagree with them just because they're American, even if they're good. So we've got to figure out other ways for other countries to kind of come around to these ideas without there being American proposals. So the challenge then to negotiators is how you make something like that happen, I guess. But I don't think the Trump administration is helping themselves out with the tactics that they've adopted, even if that's just sort of the general challenge that American negotiators face.
Yeah, I think, I mean, who cares, you said. I mean, more and more countries care now, and it's traditionally maybe been the big countries, the EU, the Canada, the Australia, New Zealand, and us. And we have the Ottawa Group, where Norway is a very active member, together with 13 other countries, trying to look for reform solutions, how to make a way forward in a constructive way to save the system. But I think we also see that, for instance, Norway has a special responsibility within the Ottawa Group to have a dialogue with the developing countries in order to get their views on board and see how they can sort of become more active as well. And I think we see that maybe they have seen that this doesn't really affect them as much, but that what we see now is that even they see that they will be hurt in the long run. So, but of course, I mean, we are normally with the like-minded countries like the EU, Canada, Australia, New Zealand.
And I should also say that I am aware broadly that
yeah.
Canada was also involved in this Article 25 but because we're in Norway and you were so kind to invite me, I'm going to give you credit for it. It's kind of coming up with it. So.
So on that note, thank you very much to Katja and Chad, especially to Chad for coming to Norway in a certainly busy period on WTO issues. Thank you very much.
Thank you.